Good afternoon, everyone. So this afternoon, I will actually be sharing with us insights on the importance of trust in building a successful identity program and the role of privacy as an enabler in that regard. Well, the very interesting thing is that trust has been defined to be a confident relationship with the unknown. I find that definition very fantastic because you see, oftentimes the identity user doesn't actually know what transpires when his data are being collected, stored, categorized, or even authenticated. The only thing he has to do is either to trust the process or not trust the process. So what happens to him? But the reality is this. Should he trust the process, there are positive implications on the identity program. Should he distrust the process, there are negative implications on the identity program. So the duty lies on the duty bearers, the government, to ensure that there are factors put in place to build trust in the right holders, the identity users. So pretty much, it is very interesting for us to know that in building this, we need to realize that what is trust and what is not trust. In the first instance, I would say trust is not or does not imply absence of risk in an identity program. I say that again. Trust does not imply absence of risk. Number two, trust does not imply a perfect identity program. Then what then is trust? Trust essentially speaks to having assurance of a user-centric identity and protection from risk. I would love to give a picture or illustration to that. I saw a picture recently. If you could imagine a man standing on the ground with his son on an elevated platform, and the son is asking the father, begging the father, "Dad, should I jump? Will you catch me?" And the dad says, "Son, please go ahead, I'll catch you." Whatever decision that the son takes after that time will be a reflection of trust or distrust. The truth is, because he's backing the father, he doesn't even know many risks that he's up to or he's up against. Now, so in that situation, the only thing is that he has to trust the father to be able to jump. So the duty bearers have that duty to ensure that in all situations, trust is in place. Now, so we are looking at privacy as an enabler of trust. Now, when we're talking about privacy as an enabler of trust, some things have to be put into place. Number one, there must be privacy and data protection legal frameworks. Speaking to this, I want to say here that almost all jurisdictions around the world, privacy is recognized as a right. And so it is guaranteed in most constitutions, legal frameworks, and even international treaties. When we look at GDPR, which is more or less the most comprehensive legal framework on data protection and privacy around the world, it has actually become a model for many other countries around the world when it comes to protecting right to privacy and data as far as identity is concerned. So when we have that, there's an assurance for right holders, for the citizens, that should anything go wrong with my right, should there be a contravention of my right, I have something to fall back on. I always say this, that there's the existence of a legal framework is not assurance of default or contravention. The existence of a legal framework is only assurance that there is something to fall back on. There is something to invoke for protection. And the good thing is that there are jurisdictions around the world where we do not currently have comprehensive or specific data protection legislation. But we have had courts in those countries stepping up to the occasion. the very good thing is that in my country, Nigeria, we have had instances where even without a data protection legislation in place, we have challenged contravention of right to privacy. And the court has relied on only provision of privacy in the Constitution. And the court has held that the provision of privacy extend to protect right to personal data. So we have two cases which were cited. You have the first one, Incorporated Trustees of Digital Rights Lawyers Initiative, and NIPSI. The good thing is that the DG of NIPSI is actually here, and we are happy to have actually worked on that project. So we have the second one, which is Digital Rights Lawyers Initiative, also against Minister of Trade and Investment in Nigeria. So the next one is robust and effective redress system. Now, we need to be sure that there's a robust and effective redress system for the right holders. Now, what do I mean? It is very important for citizens to understand that should something go wrong, should their data actually be breached, what do they do? Now, one of the things we need to understand is that when we are talking about robust and effective system, we are looking at a situation where a citizen can approach the court at all times. And in that situation, there must be provision in the legal framework for citizens to do that, not only as a privileged citizen, but even indigent citizens. So the next one is that there must be provision for NGOs and other organizations to approach the court for enforcement, to seek redress on behalf of citizens. Like we all know, legal proceedings are not cheap in any country, including developing countries. So it is very, very important to really have such a situation when another citizen can approach an organization and request enforcement of his rights. The next one is readiness of the court. I so much appreciate preparing this position. There was a case in India where a particular justice called Justice Putaswamy challenged the national identity program of the nation. I need to lay this foundation. India, in its constitution, does not have a single provision for privacy. But when this issue came up, this man approached the court, relying on provision of Article 21, which actually borders on right to life. So because they had a ready court, the court was able to extend and expand the scope of that provision to protect right to privacy. And that's a call to our courts. It's a call to our judicial officers. Because laws actually are not made on a daily basis. So what happens when we don't have a law that speaks directly to the media situation? Do we fold our hands? No. Do we watch while people's rights are violated? No. So the next one is rights awareness. People on the streets need to be aware that they have rights. And as a matter of fact, I need to speak to this, that this speaks to the integrity of the identity system. Remember here we're talking about trust. And we are saying trust is not having a perfect identity system. But trust is having a user-centric system and the one that protects me against risk. So when I know that anything goes wrong, I should be knowledgeable enough to know that I have rights I can enforce and there are procedures for such enforcement. Yes, the next one is privacy by design. It is very important to build privacy by design into an identity system. And I also advocate that this should actually be incorporated into the legal framework. We must be sure that government any day, anywhere, will want to overstep its bounds. But the moment we have such provisions in the law, then the government itself is put in checks. at all times. Transparency, accountability, and communication. Well, transparency is actually one of the most important factors when it comes to building trust. When you do something for me, for my interest, and I do not know the extent of what you're doing, then of course, I cannot even walk or stand up to trust that process. So one of the challenges we have, particularly in most emerging democracies and developing countries generally, is the fact that the government keeps their citizens in the dark as to what they are doing. And you see, no matter how hard you're working for them, when they don't know what you're doing, then of course they can't appreciate it. And when they do not appreciate what you're doing, they cannot trust that process. Now, there was a particular case that was referred to where the former president of Estonia actually made a remarkable statement about what was one of the secrets of their identity success. Most of us here can actually attest to the fact that Estonia has one of the most remarkable successes when it comes to identity around the world, even in Europe. So, because the government in Estonia repeatedly assured people of their privacy, that look, your information, your data will not be used without your knowledge. Your information will not be processed without your knowledge, without your permission. Then, of course, the people can go all out and trust that system. So we cannot trust the system without having in place transparency, accountability, and communication. The next one is limiting national security exceptions. I always find this subject very interesting. Almost all over the world, the government is all out to cite national security for violating people's rights at one time or the other. And this is not actually exclusive to African countries or Asian countries, but even in the United States, it happens. So the question is, are we saying national security issues are not legitimate concerns? Of course not. Personally, I believe that we need to, first of all, have a country that is safe for us to live, safe for us to conduct business before we can even talk about exercising our individual rights. But the truth is, when you check most data protection legislation across Africa, proposed legislation, you come across clauses that says, in cases of national security, principle of data privacy shall be exempted. That is very tragic. Because we are actually dealing with people, most of the time, who are power hungry, who don't actually want dissent. So the next thing they need to do is actually to violate your right by just mere citing national security. So what do? First recommendation. In any case of national security, public safety, public defense, we can only make it in a way that principle of data privacy are restricted, not exempted. And when we have such restriction will be subject to clear safeguard. Interestingly, Nigeria has one of the most fantastic safeguards for violating rights in its constitution. In Section 45 says that this right, including right to privacy, shall be invalidated, one, by a law. And that law has to be a law that is reasonably justifiable in a democratic society. That is rather robust. Because for me, some things have happened in Nigeria and some other countries, in Togo and all of that, shutting the internet and what have you. And some people will be quick to make reference to Hong Kong, to China. And my response to them is, check your constitution. For God's sake, you're Nigerian. Your constitution says your right to privacy shall only be limited by a law. It cannot be by directive of the president. Oh, we have a judgment to that effect in Nigeria. So I think the Court of Appeals sitting in Lagos State gave a judgment that when a particular right of a student was violated, and the court visited the ground for violation. And the court found that it was the governor's directive. And the court said, no, the governor's directive does not constitute an act of the National Assembly or a law by the State House of Assembly. So the court nullified that position. So one, it has to be by a law. And that law has to be reasonably justifiable in a democratic society. So having said that, we are saying that, yes, national security is a legitimate concern. But then, beyond just flashing national security for every intended act of violation of right to privacy, then we must be able to justify that, look, this and these are the steps to be taken to be able to bring up national security when we want to restrict right to privacy. The next one, necessary aid for vulnerable persons. All around us, we all have vulnerable persons. We have children whose rights can be easily violated without redress. We have very poor people. We have persons living with disabilities. So speaking to this is that the government has a responsibility as a duty bearer to its right holders to ensure that necessary aids are put in place to ensure that these persons who are clearly vulnerable have the access to enforce their rights. Like I said, and I want to reiterate, that having a good, having trust in identity system is not having a perfect system. In fact, the right holder is aware that there are risks, but now he has been equipped to challenge any act of risk or contravention of his right to privacy. So the next one is even protection. Oftentimes when we're talking about protecting people, we try to protect the right holders only against the government and some big corporations. But that's actually not enough. We need to do more. We need to focus on even development agencies. We need to look at NGOs. We need to look at other critical stakeholders in the ecosystem, how their conduct can actually violate the right to privacy of the people, which is very central to building trust in the identity system. Then, of course, trust framework. Yes, of course, around the world today, we have trust framework being developed. And, of course, I listed about 5 countries there: Canada, United Kingdom, Australia, New Zealand, and Sweden. In fact, I think United Kingdom has actually updated its trust framework, over time. This trust framework is a step ahead, a step further than starting with having a legislation. More needs to be done because a whole lot needs to be put in place for an average citizen, a poor citizen, a non-educated citizen to be able to trust the system. Then, of course, I'm closing with what I've called proofs of trust in an ID system. Number one, increased participation in the identity program. A good number of times, I've come across people who have said, look, I do not have, I'm not enrolled on national identity scheme because I do not trust the system. In fact, some citizens will tell you that, well, there's so much rush about this enrollment because my country is having an election. So the government needs to access my personal data for political purposes. But can you blame them? Of course not. Because as at that moment, they are yet to establish the trust in the system. And the only person who has that duty, the duty bearer, is the government to ensure that, look, at all times, we can assure you that your right to privacy shall not be violated. Number two, increased use of identity-related services, e.g. banking services. Maybe pretty much almost everyone here can actually relate to this. Anytime I come across someone who is well-educated, maybe a graduate of a program in any university or something, and they tell me, look, I don't do internet banking. The first thing is I'm shocked. But, thinking deeper, I realized that this is an offshoot of distrust in the system. Now, that fellow cannot trust the fact that everything will go well with the transfer. So, let me give you an example. I was in my hotel room this morning. I made a transfer of $1 million. That should be about $1,300. And till now, the recipient is yet to receive the money. That's very unusual, though. It's very unusual. Nigeria has one of the seamless banking services. You make a transfer, the recipient gets it return. But my point is this. Imagine that has happened to me about 3 times this week. You can rest assured that I have a whole lot of discouragement when it comes to using banking services. And using banking, internet banking services is actually tied to my digital identity. And that's it. So it's all about identity. I mean, my BVN is involved, which is called bank verification number in Nigeria. So all of these things have to do with trust. So until the citizens trust the system, they may not be able to go ahead and actually do what is needed, particularly when it comes to getting a loan on the national identity system. Then the last one, regular challenges of infraction at both administrative and judicial fora. Well, maybe this is very interesting for me as a practitioner and as one who has challenged issues of infraction of rights, particularly right to privacy, up to Supreme Court in my country. And I tell you people, when a good number of times, when I come across people and they say, look, your countries are not actually giving us good laws. They are not protecting our rights. My question is that what have you done? How many of these laws have you challenged? How many of these infractions have you challenged? But you see, when we begin to see on a daily basis regular cases of challenges of infractions of people's rights to privacy by the government, when we begin to see or witness cases of challenge to legislation, I tell you, it's a pointer to the fact that people are now beginning to trust the system. Because, like I said, that having a ready court, we need our courts to be ready to protect the right of the citizen. And since having a good ID system, an effective one, a successful one, is not having one without risk. It's not having one without contravention of right. But having one where people can say, when my rights are violated, there's a court I can approach. And the day we begin to have many lawsuits filed in court, it's actually a proof that citizens are now beginning to trust the system. Thank you so much. I will be available to take questions.